Happy Mother's Day. Hi guys, it's Kathy. I hope you're doing well. To all the moms and dads out there, happy Mother's Day. So, we're going to start off with Judge Fish. And it's a slow burn because I think they thought it would be a walk in the park, so they just are arguing lightly. You'll see. But the fireworks are at the end. Judge Fish is amazing at the end. Here we go.
State, please set a record for Brandon Crockett.
Yes, this will be State of Indiana versus Brandon Crockett, 64 D01 2010 F2, 84 87, and 64 D01 2410 F2, 10728. Defendant appears in custody in person with Counsel Attorney Myers. State's represented by Deputy Prosecutor Hammer, set for sentencing.
Thank you, State. Anything on the pre-sentence investigation?
Oh, guys, I think Zach got a real good one for us. I think so. Zach, I don't have it. I don't have Colorado right now. But I don't know what it is, but I know we all want to see it.
No, Your Honor.
Anything on the pre-sentence investigation, Mr. Myers?
No, Judge. I received a letter that was addressed to you as well and the state. It was just notifying the court that Mr. Crockett is approved for community corrections. I haven't seen it filed into the cause number, and I don't know what the practice up here is.
I haven't seen that at all. Can you approach with that?
Yeah, I have not seen that yet either.
I'll make you a copy, Chris.
Thank you.
Thanks. Is this your only copy?
It is. I'm sorry.
It's all right. I'm a little perplexed about why I didn't have one from the proponent, but alas, things happen. In the meantime, you said you had no changes, corrections, or additions to the pre-sentence report?
I'm going to play it today.
My name had an extra E, but I'm not worried about that.
Okay. We'll note it for the record.
Thank you.
Evidence or argument for sentencing, State?
Just argument, Your Honor.
Okay.
I didn't know if you were going to let us do argument after if he had any evidence. I didn't know.
Do you have evidence?
I would like Mr. Crockett to testify, Judge.
Okay. You want him to testify or do you want him to make an allocution?
Both, but I want him to testify first and then do his allocution later.
Okay. Well, let's have him come up to the witness stand then. Sir, as best you can, please raise your hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth. Okay, thank you, sir. You can be seated.
I don't answer file it.
Should have been already been work.
Barely see over the.
What's that?
No, I was little. I could barely see over the.
You're good.
Judge, I would move to admit this acceptance letter regarding Exhibit A.
Tiffany.
Not sure what the
Hi,
practice
Tiffany.
is, but I want to make sure.
Tiffany, it's the next clip that you want to see.
Well, why don't you take this copy and take it over to the court reporter, have it marked as defendants 1, because we don't use letters, and then we'll put it into evidence.
Here.
The state may object, but I don't think they'll do very well with that one.
I wasn't planning on it, Your Honor.
Okay. Say what? I don't know. We'll have to have a word with the people. All right. So defendants 1 is admitted. The March 27th, 2026 letter from Amy.
I got a real quick housekeeping now that Tiffany's here. Tiff, if Anthony gets off work, you're going to have to take over my live stream for a moment.
Putman
Thank
in
you.
the PACT office. And attached to it is the second page from West Central Regional Community Corrections. Go ahead, sir.
Mr. Crockett, you have already pled guilty for dealing methamphetamine in October of 2020. Can you explain to the court what was going on in your life at that time?
I was just released from prison. I did approximately 15 years. I was released to house arrest at my parents' house. through the CTP, the Community Transition Program. I stayed there for approximately 45 days. I moved out and got involved in a relationship. I got engaged. I got engaged.
Guilty.
And, just being out in the open in society was really difficult for me. I suffered from some mental health issues, ADHD, ODD, which is oppositional defiance disorder, severe anxiety and depression. Just going to work and being out in the open was very difficult.
I heard 4 different clips today. Well, I was getting clips from this week today with ODD. Bull, come on.
Difficult for me. It started affecting my job and my home life. The lady that I was with she suffered from some mental health issues. She was already engaged in seeking therapy, and we talked about it, and it was something that
She's a woman,
I
of
felt
course.
like I needed to do.
Redundant.
I did that.
Hey, hold on. Clint, can you step up one step? Pull the board and see him. It's easier for her to transfer. Go ahead.
And, excuse me. I started seeking therapy. When I would talk to the therapist, they talked to me about prescribing me medications. They asked me if I was an addict, if I'd ever been addicted to drugs, and I was honest with them, and I told them yes. They weren't willing to prescribe me certain drugs because of my addiction, a disease. So I tried different medications. It didn't work. A few of them made me suicidal. So I just quit taking medication, period. The workplace that I was at, my boss introduced me to methamphetamine. We had some lengthy conversations about anxiety and ADHD, and he suffered from the same thing, and he used. And, I decided to try it. When I tried it, it was like a miracle drug to me. It allowed me to focus and function and pay attention. I didn't feel like the whole world was against me. I could go out in public. I could hold my job. And then me and my fiance started having some problems at home.
But at that point, why? I mean, if you're having an issue and someone came up to you right now and said, here's some meth, it's going to make your issue better. How many adults would just say, that checks out? Meth will make my issue go away. Absolutely. Give it to me. I mean, okay, let's just say it does. Let's just say I get off work, I work a double, and I'm all out of lidocaine patches. Thank you, Martha. And someone says, here's some meth that'll take your pain away. At this point in my life, I know what meth does to people. Everybody knows. It's not a secret. Why would you say, that checks out. I'm gonna take that. Why would anybody do that?
He became physically abusive. I was on parole at the time. That was my parole address. And I knew that if I stayed, that I was going to get in trouble. So I moved back with my parents. I lost my job because of transportation issues. My family, my mother is elderly, and she couldn't get me back and forth to work. So I lost my job. And then I came in contact with an old acquaintance that at the time was a meth dealer I wasn't aware of at the time. He offered me some work. So I went and helped him. He would go to these places and buy pallets and resell them and stuff. So I'd help him go unload and stuff.
If you guys only knew how bad this man is making it for himself right now by the words that he's saying. Every single word he's saying is making it worse and worse and worse.
Then he revealed to me that he dealt meth. At this time, I was already using it from my previous job. So I started working for it and continued to use I call it to quiet the storm, to help me function.
Hi, Thor.
And then he talked me into actually dealing it for him a few times to, my proceeds or my reward was some drugs. And that's what led me to commit the offense that I committed.
the guy you were working for or working with, he was one of your co-defendants in these cases, correct?
Yes, sir.
Do you have any contact with any of those co-defendants?
No.
Do you know where they are or any?
I know Jeremy, the actual guy that I was selling drugs for got like a couple years probation, but he's done with it now.
Okay. To the best of your recollection, how long have you been continuously incarcerated since this point in time? I know there's a span you were out, but how long have you been at the Porter County
Almost
Jail?
5 years,
How long have you been sober?
that whole time.
And when I say sober, I mean no.
I've been sober since this incident has happened.
Okay. Since you've been at the Porter County Jail, what programs or classes have you taken?
I was never really interested in like the domestic violence and things like that because I don't have that issue. I was always in seek of the substance abuse programs. So since I got here, well, probably the first 3 years, I tried to get into the CDA or therapeutic, but if I'm not mistaken, it was federally funded, and Judge Fish court ordered me into the CDA, but they denied me because of my level of felony. From my understanding, they took that funding or something happened to where we were now allowed to participate in the CDA and the therapeutic. I didn't get a chance to participate in the CDA, but I was accepted to the therapeutic community, and I just graduated from that, and that's when my life changed.
What did you
7
learn?
weeks.
What did you learn in that program?
I learned a lot of life skills, coping skills. Like I said, it took me about 7 weeks. When I knew I needed a new way of life, a new way of thinking. I had to think different. But it wasn't until about 7 weeks into the program that I actually started to understand the dynamics of addiction. And within that time, the group of guys and the people that teach that
See, except his crime wasn't really addiction. That wasn't his crime.
class made that environment comfortable enough for me to actually be vulnerable for the first time in my life and talk about some trauma, childhood trauma, my depression, my mental health illness. And it allowed me to just to open up and be brutally honest about it. And I never felt comfortable enough to do that. And it's changed my life.
You've been to DOC before,
Yes, sir.
and I think the PSI said, regardless of what happens here today, you're going back to DOC till 2032, correct?
Yes, sir.
What programs have you done at the DOC?
I've done almost 25 years in prison. I'm 46 years old, so most of my adult life has been incarcerated. I can honestly say that, the last time that I was in prison, the 14 and a half years or so, I engaged in a lot of different programs. I've done Thinking for a Change, substance abuse. I got my GED. I got 2 DOL apprenticeship programs for teacher's aid and education and training. I lived on a school dorm, and I actually taught the GED classes. But all of those weren't to learn or
Down
better
customers.
myself. All of those were to trick the courts and try to get out of prison early.
And to sell drugs to college kids,
I just wanted to
high
make it
school
look good
kids.
because I was continuously using in prison the whole time. I hadn't grasped the concept of the addiction as a disease and why I was doing it.
Using what?
Narcotics.
Okay. Did you ever do that RWI program, or it had a different name back then? But
No, I've never participated in that. No.
okay, is that something you would want the court to consider in this case?
Yes, please.
All right, and I think probably more important to that is you've been approved to do house arrest in Warren County, correct?
Yes, sir.
What's in Warren County?
Warren County is where my parents stay.
Okay, you'd be living with your mom.
Yes.
Where is your mom today?
My mother's at home. She's really ill. She's got she keeps getting what they call septic of the stomach or something like that, where she's lost like 40 or 50 pounds, but she's almost passed away twice the past year. But she couldn't make it here today to support me because of her illness.
Can you describe your relationship with your mom to the court?
She's my best friend. I talk to her every day. My hopes
Same.
and dreams are to one day get out and make her proud. For many years, I failed to realize that
I
not
just
only
wanna
do my
make my
actions
mom
affect
proud.
me and the victims and what I've done, but my family also. And just to see the stress that I've caused her is, it's unbearable.
If you were to be placed on home detention, where would you work?
My brother owns his own business, Thompson Electric. He's an industrial and commercial electrician.
Okay. And I believe the PSI said you've been on home detention before, correct?
Yes, I was released in 2019 to home detention.
Okay, and I don't remember, but I hope you do. Have you ever been on home detention and not successfully completed it?
Every time he's not
Yes,
successful.
as a juvenile,
Okay, when was that?
like maybe early 2000s or late 90s.
Sure. We also explored this restoration court avenue, correct?
Yes.
What is your understanding of restoration court?
Restoration court, I believe, has to do with addiction and mental health illness combined.
Okay, and is that something you've
Geez, if only your crime had to do with addiction.
been interviewed for?
Yes, sir.
What is your understanding as in regards to being accepted into that program?
I was told that I had to be agreeable to the prosecution, but I talked to a psychiatrist from Porter Stark that came and seen me, and I did the evaluation and had a lengthy conversation with her. And we talked about the certain medications that they would give me that they weren't willing to give me before. But she told me she believed that I needed to be out and see a psychiatrist and get on the right medications.
And somebody filed something about this $10,000 bond. I told you about that. Correct?
Yes,
Where did that money come from?
my mother.
Okay.
My mother, some of it was mine. When last 14 and a half years, I worked inside as an education tutor, so I got paid. And then in DOC, they take out what they call a reentry fund, and they put it in a trust fund where you can't touch it. That is given to you once you're released. So a few $1,000s of that was some of the money that I had saved from working inside DOC.
I understand. Do you have any preference with what the court does with that bond?
No, sir.
What are you asking the court to do with you today? And let me just tell you, this is not time for your statement of allocution. This is, you know your history. It's in the PSI. The court knows your history. What do you think the judge should do?
I would just like a chance to be able to use the tools that I acquired in a therapeutic.
You're
No,
right, he doesn't.
Whoever in this room that participates in it or whoever is for it, I'm going to tell you right now that it's a very good program. It will change people's lives if they allow it to. I would just like a chance to prove
I
that,
should send my children to that
I learned some
program.
valuable lessons. I take accountability for my actions. I know I broke the law, and I know I apologize for polluting your community with illegal drugs. I wasn't doing that to be a drug dealer to make a living from it. I was doing it to self-medicate. My mental health issues were just so overwhelming. I couldn't function. I just couldn't function. That's the easiest way for me to say it. I would just like to have like everybody else that was involved in this case, I'm the only one that's set in jail for it.
Judge, I don't have any other questions of Mr. Crockett at this time.
Okay, thank you. State.
No, Your Honor.
Okay, thank you. Sir, you can step down now.
Thank you.
Thank you. Any other evidence, sir?
Just a statement of allocution.
Okay.
Thank you.
Argument state?
Yes, Your Honor.
So I'm sorry, Eileen, that sucks.
Your Honor, this isn't a case of just simple using. This is a case where somebody has sold ounces, specifically in the one case, 204. That is not personal use, nor will it ever be personal use for methamphetamine. So I believe it's semi-disingenuous.
Absolutely. If he had a raging addiction and he had 204 ounces, no, he dealt it. He was a dealer. Thank you so much, James. Thank you. He was killing everybody.
Say he wasn't doing it to sell drugs to other people, because at 204 grams, that is not a level somebody's using. This isn't just slightly over the statutory amounts. This is well over multiple times the number that it would take just to complete a level 2 felony, as it begins with. And he didn't do it just once, not twice, but 3 times, even with the cases that were dismissed. Again, that would go towards the amount exceeds what is necessary. This again shows the pattern of dealing, and that this isn't a first-time thing. The PSI specifically notices that he's had multiple write-ups in disciplinary conduct while in prison and or in jail, specifically also at least one incident at the Porter County Jail. In his juvenile history, he had an informal adjustment for conversion back in '94, felony theft, which he was unsatisfactorily discharged for in 1996, and a burglary, which then was filed as an adult, and he was guilty as an FC felony. He violated probation in that, is looking through the PSI multiple times. And then as an adult, he had a conviction for forgery. And most importantly, within that FC conviction for forgery, he was found in contempt and sentenced to another 6 months in the Warren County Jail. He had multiple revocations in this file, failed to appear, and was released unsatisfactorily. In 2005, he had an FB, burglary, and the habitual, which he served 10 years, or is still serving time, and still is on parole for 10 years on the burglary and 20 years on the habitual. And he's violated parole based on this case and other things within his thing. His earliest possible release date is June 28th of 2032. In 2005, he was also found guilty of misdemeanor resisting law enforcement, which was straight jail time. And there was an escape charge with that was dismissed. In this case alone, he has failed to report when placed on supervision back on December 14th of 2020. He's failed to comply and then failed to appear, while after being placed on bond on October 28th, 2022, on December 2nd, 2022, defendant commits the new offense while out for resisting law enforcement in the misdemeanor, which he served time for. So a summary is he's been had 3 cases as a juvenile, 1 felony, 1 waived up, 8 arrests as an adult with 2 misdemeanors and 8 felony. This is the 3rd drug case he's had. He continually violates parole in pretrial. He continues to commit new offenses while out on bond or either pretrial release. In each case, except where he was incarcerated, defendant either fails to appear or ultimately that case has to be disposed of with him serving any sort of significant incarceration time, Your Honor. He has been allowed every sort of opportunity, probation, etc., and he has squandered it. He has been given every single time, and every single time he's been given the opportunity to be out with society, he fails at it. And it just does not seem to be a pattern that would be good to put him back on probation for. He is a high risk to reoffend based on his criminal history. He has, again, been given boys' school, incarceration, programming, and none of that has taken. Everything has been an unsatisfactorily discharge from probation or otherwise in all of those cases, and the defendant is a high danger to the community given all of that. And Your Honor, additionally, pursuant to 35.
That means he does dodgy things with his chances. Dodgy.
52.2, he
Embezzler.
the sentencing range is anywhere from 10 to 30. However, we can only suspend that part of the sentence that is in excess of the minimum sentence. So that would mean 10 years would have to be DOC regardless of any other programming here. However, Your Honor, given his track record, the seriousness of the offense, the amount of the offense, state also adopts the aggravators as mentioned in the pre-sentence investigation, and it would also suggest that the mitigator, the statutory mitigator would not apply of he's been that rehabilitation or other methods would be beneficial because he's been provided those and those have not been beneficial in the past, Your Honor. Given that, state would just be asking for 30 years Department of Correction, none suspended.
Okay. Thank you. Mr. Myers?
Before we hear more bullshit, I just got to tell you, dodgy and embezzling, I think it'll take me another year or so to get it out of my system. So be prepared. Every stream.
Judge, sometimes in this business, we are in situations where the person who committed a crime a long time ago is not the same person who's in front of us for today. And I would submit to you that might be the case here. We understand that there is a terrible criminal history here, and it is a vicious cycle of DOC out, DOC out, DOC out. What we're asking this court to do, because he's already going to be in prison until 2032, is we want to craft a sentence that would break the cycle, so to speak. And what I mean by that is there are several programming available, or there are several options available to Mr. Crockett where we can say, no, you don't have to get out and go back to DOC, get out and go back to DOC. For example, if this court orders him to DOC, we would like him to be able to participate in recovery while incarcerated. I also think there's an avenue through restoration court. And my understanding is they interviewed him and they said, well, it either needs to be in a plea or the court needs to order it. And I would ask the court to order that if it's deemed appropriate. I don't know a whole lot about the program other than it seems like it would be something that would be very helpful and beneficial to him. He has employment available to him. He has a house available to him. He can go down there with his parents. And he's screened and approved for house arrest, and there are several programs he can avail himself of while he is on house arrest. Our request today is, Judge, that you consider that sometimes the system we have set up will work. We can take somebody and break them and say, you can't keep doing this. You're not going to keep doing this. You're either going to end up dead or you're going to change. Mr. Crockett would like the opportunity to show this court that he has changed. Thank you.
Since it's Mother's Day, we should let the mothers of the children he sold meth to decide.
Mr. Myers. Mr. Crockett, this is your chance to say whatever you might like to say before I rule on the case, if you'd like to exercise that right, sir.
He's asking you if you want to.
I just got a letter I'd like to read that I wrote from graduation when I graduated therapeutic.
That's fine. If you want to point the mic towards him a little more directly, thank you.
My name is Brandon Crockett, and I am an addict. Enslaved to my addiction for the past 34 years. I decided to join and participate in a therapeutic community program because I was in desperate need for a new way of life. In the beginning, I just sat back and observed. I listened to every word, every story. And it quickly became apparent to me that I sat in a room with a group of men that were struggling with the same crippling disease I had been living with since middle school. I couldn't believe that these grown men were sharing stories fearlessly about some of the same things I had experienced in life. I came to have the utmost respect for them, and my admiration grew for them like nothing I've felt before. And that's when my life changed. My perspective on recovery, my
See, if he was real, he'd be crying right now.
thinking process. The moment came when it was my turn to speak. I was scared, filled with trembling and anxiety.
Dealing
I said a
drugs.
prayer and I spoke. I allowed myself to be vulnerable, which was something I had never done. I was ashamed and embarrassed about the mental health issues I've had since a child. I want to be accepted to fit in. I felt weak or less of a man if I were to open up and speak about my depression. What kind of man admits he's contemplated suicide as a teenager? I quickly realized that a real man speaks about his troubles. Speaking to someone about them is a sign of courage, not a weakness like I've thought for 46 years. This program has taught me many valuable lessons from life skills, coping skills,
And he starts his work on Tuesday.
to understanding how me neglecting my mental health has played an unmistakable effect on my journey to quiet the storm. It has put me in contact with people that care, resources I never knew existed, and with those tools and these resources, I am now ready more than ever to face my fears and to
For the record, he's had 40 years of resources thrown at him.
continue to participate and surround myself around people in recovery. We are a family, and I no longer feel alone, a misfit, a worthless human being. Thank you.
All right, sir. Thank you. Is your mom still at 4?
Yes, sir.
Okay. So the idea of purposeful incarceration here, or recovery while incarcerated, isn't overly appealing to the court. And the reason is because of the automatic modification that would be presented. I wouldn't think that I would want to consider a modification in this case until Mr. Crockett will have served a significant portion of the sentence. And I think the recovery while incarcerated program would accelerate that in such a way that it wouldn't be beneficial to Mr. Crockett, because it wouldn't satisfy a minimum amount of time, and it wouldn't potentially satisfy the remaining sentence for the parole hold. So I don't think recovery while incarcerated is the right way to go. The restoration court,
I don't think that you should get recovered while you're incarcerated. So no to that.
probably a worse option given the circumstances, because what I'm told now is that if there wasn't a prison sentence forthcoming, that Mr. Crockett would return perhaps to West Lebanon and simply can't participate in the restoration court and be out of county. Additionally, if I do the
So that would be a no.
restoration court, that would have to be a sentence with probation, and he would have to be on probation in the restoration court with probation monitoring his progress in restoration court. And I don't think Mr. Crockett is a good candidate for probation. So I would reject both of those concepts, given the potential for sentencing here. I will find the aggravating circumstances. Mr. Crockett, I think you've got a terrible history here, full of trauma and full of prison time and juvenile work. The state makes a valid point about how none of that has helped amend or modify your behaviors. I mean, if coming up to the Porter County program has had such an impact on you, I think that's a wonderful thing. But it's difficult for me to conceive of a situation where you have the arrest in October of 2020 and all what really amounts to shenanigans related to your appearances in court and going out and picking up other charges while you were out. All that, along with then picking up the 2024 charge for the exact same crime, doesn't really speak to the court that you've learned much from your situation here. So good for you if you've got now some tools that you'll be able to use. If once you get out of prison, you'll be able to have the benefit of those things. So when we sentence,
When you're
we start
70.
with the advisory sentence, which in a level 2 felony is 17 and a half years. We move up or down from there based upon aggravating, mitigating factors. There are no mitigating factors here. There's a significant aggravating factor, the history of criminal and delinquent behavior in your situation. And then it's also significant, the violations of pretrial release and parole and probation for you. So given those things, you're into a severely aggravated sentence, and I will sentence you to 25 years in the Indiana Department of Corrections. I will suspend none. That'll be executed time. There was the cash bond posted in the case. I previously entered judgment of conviction, so I don't need to do that again. I'm just sentencing you now. From the cash bond, the court will retain court costs, probation, well, there's no probation fees, jail booking and sheriff's death benefit fee. And then the remainder, I have 2 letters now from Ashley Aldridge. One of them was written to me in May of 2024. The other one was just written the end of, well, beginning of this week. Both of them say to refund the bond money. She's basically waiving her right to the refund of the bond money. And I respect that, but I'm sending it to your mother.
Right.
Okay, so that will go to, saw her name in here as well. What's your mom's name?
Bonnie Thompson.
Bonnie Thompson at 4270 West 3rd Street, West Lebanon, Indiana, 47991. And I would decline to put Mr. Crockett on any form of home detention at this time. I don't believe that there was a bargain for waiver of the right to appeal in this case. Mr. Crockett, you have the right to appeal the sentence imposed herein. In order to do so, you must file either notice of appeal or motion to correct error within 30 days of this date. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you can't afford an attorney, I'm obligated to appoint one to represent you at no cost. Do you plan to appeal?
Listen, the dollar store is still open for 14 more minutes, Nan. Hop in that broken down car, head to the dollar store and get 7 pairs of just readers. And then just place them all over the place. And you'll be so happy.
The sentence here, sir. Okay, if you change your mind, are you going to represent him if he changes his mind? You would, sir?
Yes, unless he fires me.
Okay, well, if you don't have representation and sometime you change your mind within the next 30 days and you need the appointment of counsel, write me a letter. Don't think about it too long, no, because the mail takes a few days as well. Did I miss something? And we will dismiss the charges in 2410F2-10728. I'll remain it to the custody of the Porter County Sheriff for transport down to the Indiana Department of Corrections. And we're adjourned. I wish you the best of luck.
Thank you.
Thank you.
Zach sent me a clip after the stream started. And I just edited it, and it just got done right now. We are adjourned. I was waiting for it to crawl along. I didn't think it was going to make it. That's called luck. Professionalism. God, I'm so professional. I can't stand it. All right, guys. You lost them all, Tiffany. You lost my glasses, and I'm dying on that hill. Guys, I don't know what we're about to see, but apparently, oh my God, we need to buckle up. Apparently, this guy is completely psycho. So, I'm gonna start dating soon. We're gonna see. Tiff will move to Colorado. I think we found a new daddy. No, I don't hear anything yet either. Calm down. Everybody
Thank you.
relax.
The court comes on today for a plea and sentencing. We have 26M92, 26M81, 25M374, 25M373. Mr. Janowicki, if you could please be seated at the defendant's table. Mr. Janowicki does appear in person, pro se. We have Mr. Ulrey from the District Attorney's Office. Have the parties come to any resolutions?
Yes, Your Honor. May I approach?
You may.
We have a global agreement. We're pleading in one case for the dismissal of audits. With a domestic violence evaluation without the client suspended on first try probation and 24 months of unsupervised probation. And I can go into specifics of why we chose the unsupervised probation, given the fact there are multiple cases at this time, Your Honor, if the court would like.
Unsupervised probation?
That's correct, Your Honor.
How is he going to do UAs and domestic violence treatment and be
We were going to set out a review date in 1 year to see the progress of his domestic violence evaluation. The reason why we decided to go with unsupervised probation for an extended period of time is due to the
I'm sorry, miss. She could marry Judge Fish and then be Judge Fishbowl. Yep, sorry.
financial limitations that Mr. Janowicki has. He's communicated to the public, to the people, that any sort of probation would cause financial strain of
Bobby, it's
him
your
coming
fault.
here from BB, and the fact that he has trouble accessing good transportation. And I believe it's almost $100 to $200 for a trip from there and back. So we do believe the unsupervised probation for the significant longer period of time would help get to that sort of resolution where he can still be under the unsupervised probation, but still have some responsibilities of what he had to do. And I do believe the domestic violence evaluation also promotes the community safety as well, which I understand was a portion of the issue, given the fact there were outstanding cases at the time.
The court's not going to accept unsupervised probation. Mr. Janowicki, you've had a history of domestic violence. You've also had a history of using alcohol. I cannot, me personally, or have the DA personally police you in regards to your modus sobriety, and I'd be ordering standard terms and conditions as modus sobriety, including you following your domestic violence evaluation and treatment. Part of the domestic violence evaluation and treatment and that type of domestic violence, in regards to how many multiple cases you have, I do not believe unsupervised probation is appropriate. I would grant supervised probation if you wish to do that instead.
No, I will take it to trial, Your Honor.
Okay, so you wish to take
Yes, I wish to take a trial.
Understood, Johnny.
So what I'll do is I will set the matter over for arraignment, and I will set each case for trial. Mr. Janowicki, I'll have you back. If you wish to, let me advise you as to your arguello rights, and then we'll set the matters for jury trials. Do you have the rights? Do you understand that you have the right to be represented by counsel throughout these proceedings?
Yes, Your Honor.
Do you understand that if you cannot afford an attorney, that one could be provided to you free of charge?
Yes, Your Honor.
Do you understand if I appoint counsel, do you understand I will appoint counsel?
I'm going to bump it forward just a little bit. Oh, I meant to say thank you, but I was getting my stream ready when I saw your text. Thank you for your happy Mother's Day, Josh. Thank you for the roses. Hold on, I'm just looking. This is the guy we want right there. All right, somewhere around here.
Mr. Nettelblad on behalf of the defendant, and we have a witness ready to go.
I'm so excited. I can't wait to see what this guy does. I'm in the mood for some Doritos and Cheetos. I don't know which one.
Have the parties come to any stipulations or agreements?
Not this time, man.
No.
In regards to this, I do have one
Cheetos.
motion to dismiss
Definitely
for
Cheetos.
count 1 and 2 based on the unconstitutionality of the statutes or an alternative as applied. The court notes that we will be swearing the officer in and taking testimony here today, I believe. Mr. Ulrey, is that correct?
That's correct, man.
What's your name, sir?
Is he
Deputy John
smiling?
Mitchell.
Mr. Deputy Mitchell, if you could please take the stand, I will swear you in.
Your Honor, the purposes of whether we need to address it, we just ask the court to take judicial notice of the affidavit for the purpose of this hearing.
Okay, I'll take that and also take testimony. So the court will take judicial notice as to the affidavit in the court's file. Deputy Mitchell, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to provide the court is the whole truth and nothing but the truth?
I do.
Yes, ma'am. Yes, Your Honor.
And Mr. Wade Mitchell, I'm not swearing you in at this time. It's the officer.
Thank you.
No worries. Thank you. And Deputy Mitchell is now been sworn in. Mr. Ulrey, you may inquire.
Thank you, Your Honor. Hello, Mr. Mitchell. How are you doing today?
Good. How are you, sir?
Doing well. Can you please state your name and occupation for the record?
Yeah, my name's John Mitchell. I work as a deputy for the Chaffey County Sheriff's Office.
And how long have you been doing that for?
Approximately 5 years.
5 years?
Yes, sir.
Thank you. Are you aware of a person named Mitchell Wade?
I am.
And who is that to you?
It was a case back in 2024 that he was the suspect of in a case involving Facebook messages to an Emily Bolter.
Can you kind of go into specifics about what that case entailed?
Yeah, so I was approached by it was Emily Bolter's father originally on County Road 321.
He looks like he's proud of what he did. He's like excited because everybody's going to find out what he did.
326. And Mr. Bolter had told me that his daughter, Emily Bolter, had received some vulgar and concerning messages via Facebook from a Mitchell Wade.
Nuh-uh. He's already lying. Kids her age don't use Facebook?
Basically, Emily felt threatened, felt that the messages were out of the ordinary. There was no reason for them to be sent to her, as they had not seen each other for multiple years. They used to work. Can't recall where they worked, but it was like a Christian camp is where they worked together. But that was, I believe they were either still in high school or just out of high school.
Understood.
And that was the only time that they had really had any kind of conversation. So this came out of the blue. She was very concerned of the messages just due to the nature of what they said.
Yeah. Were you able to take any photos of the messages?
I took photos directly from Emily's phone.
Thank you. Are you able to authenticate the photos you took if you saw them?
Yes.
Your Honor, may I approach?
You may.
These are real, authenticated copies.
Martha, please do not talk to me and Micah about lawyers who grin, please. Stop, Martha. No.
Photos to the question?
Yes.
Thank you. Just go ahead and just read this out. Your Honor, if you will, let's move in for the motion. Sorry. Move for the entry of Exhibit 1 of photos.
Exhibit 1,
That's correct.
Mr. Nelbud.
I've never seen these, Your Honor. I don't know.
Can
what-
you show them to defense counsel?
Yes.
So I have 3 kids. Stupid lawyer. I have 3 kids, right? For 2 of them, when you say I'm going to take a picture, smile, whatever, 2 of them just smile. And one of my children, every single shot has I don't know how to, like an Instagram face or a TikTok face or whatever. Like this child, and I'm not going to say if it's a boy or a girl because that'll narrow it down too much. This child puts on this exact same face every single time there's a camera near this child. Boop, it comes on, and it's really cute. It's a great face. This child's pictures are amazingly beautiful, but she has one face that it's like automatic. It's her ABCs she does not know as well as getting this face on. It's like built into her. It's pretty amazing. No, I'm not replicating his smile. Look, he is blinking. He's alive.
And Your Honor, for identification purposes, since the defendant is over WebEx, is there a way the officer can get video of Mr. Mitchell?
Yes, and do you have WebEx up at this time?
I can pull it up.
You came at the right time, Anna. This is the good one.
May I approach WebEx?
You may.
Your Honor, regarding the exhibits, I don't have any objection for the purpose of this hearing, given the content of the message, the purported messages. However, should they be submitted, I think it might be wise to do it under protected or restricted status.
I'll take a look at the exhibits and we'll decide whether they need to be suppressed or not, or sealed, but I'll enter them as Exhibit 1 for the purposes of this hearing. Thank you.
Just for the record, would you be able to identify Mr. Mitchell?
I would. I've only seen him via Facebook. I have never seen him in person, but if he appears to be the individual from the Facebook page, then yes.
Understood.
What
Your Honor,
is wrong
question.
with Mr. Wade?
You may.
We all want to know that.
Please tell me what's in
Plaid shirt, button up.
it.
The good news is, since Mr. Wade is on Zoom, any exhibits that they talk about, they're going to have to show on the screen. So these text messages, they're going to be shown. Now, guys, children, you just heard them say that he sent vulgar text messages to this daughter, right? That means if they put the text messages on the screen, they're going to be vulgar text messages. Okay? There's your warning. You got I'm going to get comments later on.
The court will let the record reflect that the defendant has been identified via WebEx at this time.
Your Honor, is the court need time to look over the exhibits?
Yes, and I will mark them as Exhibit 1.
Don't make him an emoji.
And I will admit
He's too
Exhibit 1 at
scary.
this time.
Thank you, Your Honor.
Thank you. Do you wish to have them back for reference?
Yes, Your Honor. Mr. Mitchell, please.
All right, so it shows Mitchell Wade as the Facebook user that is sending the messages. The start of the messages began at approximately 5:27 a.m. And I'll just read them in order. It goes, I'm going to rape and murder you, Lil Ho. Cut off your fucking toes. Your whole family will burn forever. Everyone you ever knew, back to hell you go, bitch. Watch you eat your horse first. Then cut your pussy to your mouth, lil dead cunt. COVID is your little pussy. Go kill yourself and stream it for me, please. He spelled please, PLZ. I want you to end your life now, lil bitch. You should never teach again. You should never breathe again. You should have never existed, and I'll make sure of it. I hope you sleep well. Enjoy those toes. Better eat all that hair you shave off. Pluck those eyebrows like I'm gonna pluck off your titties. You are the reason for hell. Google elementary school deaths. I'll find you and everyone that you love. Tell Colonel Hawthorne he is a bitch for me and I'm going to rape and murder you. Fuck your little ego. I'll make you a sex slave and so dumb you love it. Go tell your daddy I'm coming for you. Imagine how painful I'll make your remaining life. Excuse me, your remaining time.
Okay, I didn't give you a strong enough warning label on this one. Sorry, guys.
Can't wait to watch you cry. Go ahead and slit your own throat because you damn know you know deserve it. And then he put a YK. I'm going to end your fucking life, whore. Send me pictures or a video of your death. No joke. Stream it now. There is an image of approximately 7 pornographic photos of a woman's vagina, multiple women's. Under that picture, there's a caption that says, here's some nasty pussy to remind yourself who you are. I'm going to pull your brains out of your nose, you mummy. Enjoy. Those are all the messages.
And were those text messages sent the same day?
Yeah, via Facebook Messenger, yes, all in one day.
Roughly how many messages were sent?
Thank you, Raven.
I didn't count them. Would you like me to count them or
If you could,
estimate?
please.
Yeah.
Thank you.
Including the pictures, 32 messages.
32. And when you took those photos at that incident, was that in the jurisdiction of this court?
Yes.
Thank you. And based off your training experience and after reading those messages, what was kind of your thought process right after?
Well, while I was speaking with Emily as well as the father,
Plot twist, he's probably married.
his first name's escaping me, but Mr. Bolter, as I was taking the pictures and speaking with Emily, it was clear that she was distraught about the messages, mainly due to the fact that it was so out of the blue. She had barely known Mr. Wade from the Christian, don't remember if it was a school or not, but from where they had previously known each other. She spoke to me in regards that she believed Mr. Wade, that he would come to the home. Mr. Coulter, the father, or excuse me, Bolter, Mr. Bolter, the father.
It doesn't matter who sends those messages. We think they're coming to our house right now. It doesn't matter, guy, girl, it doesn't matter. When we get those messages, we believe they're coming to the house. Yes.
Went as far to say that he was putting up security cameras to try and keep his daughter safe, as they truly believe that these
I think I'm
messages
autocorrect.
Mr. Wade meant and was going to act upon them.
Thank you so much. No further questions at this time.
Mr. Nelblad.
Just a moment, Your Honor. Just to be clear, you said you identified Mr. Wade based on the image on the screen that said Mitchell Wade. Is that correct?
Yes, sir.
You've never interacted with Mr. Wade before?
No, sir.
You've never spoken with him in
It was
any way,
his
shape, or
twin.
form, correct?
No, sir.
You said you saw a photo that
Maybe he has a lot of cats and it was just his cats. Do you ever think about that? Because that's a valid excuse for anything.
reported to be him associated with the Facebook profile.
Correct.
What other interactions have you had with Mr. Wade beyond that at this point?
He might start a job on Monday, Judge. Judge?
I attempted to call him. Mr. Wade had called my dispatch center and requested to speak to me, but then I attempted to call back as I was on another call and wasn't able to take it at the time. And I attempted to call his phone multiple times. He didn't answer. So I've had no communication with Mr. Wade.
Now, beyond that, you said that you reviewed messages from a Facebook Messenger account to Ms. Bolter. Is that correct?
Correct.
Those weren't signed with a signature that said Mitchell Wade and of that nature, correct?
As far as looking at Mrs. Bolter's phone?
Correct. It was just, what were these text messages or Facebook Messenger messages or both?
Facebook Messenger.
Okay. And those came through a listed account with the name and photo attached to it, but that's the entire identification process you did to say to Mr. Wade. Is that correct?
No, sir.
Okay. Can you elaborate on that?
Absolutely. So I also authored a search warrant through Facebook to get a warrant of the account. And then I was able to find the phone number linked to the Facebook account to be Mr. Wade's under his name.
Did he send these to other women too? You would think those 34 weren't his first rodeo, right?
We have a law enforcement tool that shows us, it's called Clear, and it shows us the phone numbers associated with the individual. And that was how I was able to further confirm that Mitchell Wade was, in fact, the one sending the messages through the phone number.
So just so I'm clear on that, you verified that there was a phone number registered to Mitchell Wade associated with that account.
Correct.
The account, the messages were not sent from a text number though, correct? They were not sent,
Correct. They were
That's-
sent from a Facebook Messenger.
they weren't sent directly from, say, Mr. Wade's associated phone number to Ms. Bolter's phone number, correct?
Correct. It was all via Facebook.
Okay. So there was no,
Oh, so he was
Okay.
hacked. No big deal.
and as far as any sort of IP stamps and like that, or any sort of geolocation data for when those messages were sent, did you verify those?
It showed that the IP address was out of North Carolina.
Where in North Carolina?
I can't recall. If I could look at my report, it shows it in the report, I believe.
Do you have the report with you?
I do not have it with me, but I believe prosecutor may.
So taking a step back, when you're interacting with Ms. Bolter and her father, she indicated that she'd received these messages within the course of the day. When were they sent?
It was that morning that she had reported it. It was sent early that morning. That she had reported it.
Was there any back and forth in the messages? Was any sort of interplay between the parties as far as communication?
It was just strictly one-sided.
Okay. Did
My children and their friends tell each other to kill themselves almost every conversation, like lovingly. So that part, he's young. That part wasn't so bad.
Ms. Bolter indicated that she knew who Mr. Wade was or what any prior relationship between
Yes.
us was? What was that?
They had worked together at a Christian camp.
When was that?
She couldn't remember the exact dates. It was either while they were late into high school or just out of high school. And I
It had
can't.
been some time before though,
Yes.
correct? You remember if that was months, years, several years?
I can't recall.
All right, I'll stop for a second. He didn't actually touch her. He didn't hit her, kick her. He didn't kill her. He didn't cut off her toes. He sent her bad messages. So you feel like we should know the answer to this one, guys. But what's the sentence on harassment, terroristic threats? What's the sentence on that? It can't be long. It can't be more than 90 days.
No further questions. Thank you.
Thank you. Any redirect, Mr. Laurie?
Not this time.
Thank you. Deputy Mitchell, you may step down
Thank you, Your
if
Honor.
you want to hand me those exhibits. Thank you. Mr. Ulrey, any other witnesses to call at this time?
No other witnesses, Your Honor.
Mr. Nettelblatt, any arguments regarding your motion?
Your Honor, I'll largely rest on the motion at this point.
I don't think you can get 5 years for terroristic threats. And Eileen, you're right. He's a serial killer. We're looking at a serial killer, definitely. But unless he actually kills someone, unfortunately, they can't put him in jail for life because our chat tells them to, though they should. But for terroristic threats, I don't know. Feels like we should know the answer to this. We've seen hundreds and hundreds of terroristic threats.
There are two counts here, and I think arguably two different standards of First Amendment protected speech standards to be applied. Count one is a menacing count, so I think that arguably the standard under 1A litigation would be whether this qualifies as a true threat, and under the more recent counterman standard, and for count two,
Yes, Jen.
whether the language that's alleged, I think arguably it's improper as a charge under the standard of whether it's fighting words. I think is what the people have alleged in the present case. Your Honor, I think as to fighting words, I think the question here is whether the statements within Exhibit 1 as provided by the people are so crass, coarse, or offensive as to constitute speech that a reasonable person would be provoked to a violent or disorderly response. I just don't think that fits, frankly, under the current status of the law, particularly for 189111 sub 1 age. I just don't think these are fighting words, and I think that as speech goes, this is off the mark as far as what could be prosecuted as fighting words speech. And therefore, the statements, at least as far as fighting word standard, would be legally protected. As to whether it's under counterman's, whether there's a substantial disregard, I believe it's a disregard for or recklessness that Mr., for sake of argument, assuming this is Mr. Wade in these messages, whether he disregarded a substantial risk that Ms. Bolter would be alarmed and feel threatened or imminent bodily injury under the standard for menacing. Right, I think I would contend that this does not fall in the category of true threats, that the language at issue does not rise to the level of creating a fear of serious imminent bodily harm. We would ask the court to find that it is protected speech and dismiss both counts, either as unconstitutional in their face or as applied in the present case. Thank you.
Thank you, Mr. Ori.
Your Honor, approaching the true threat.
I don't know if they can, though. Can they make him go to a psychiatrist? Can they make him get psych evals? He never actually hit her.
Argument first. The true threat is a question of fact, so that would be left up to the jury. It'd be premature to dismiss the count already before any jury would be able to find if it would be.
Oh, this is pretrial. We're not going to get an answer today because they're going to trial on this.
Considered a true fact, and using countermeasure as well as a entire factual content that the statement must be viewed as. I think it's important for the jury to understand the history and the escalation of these messages as seen by the court today. 32 messages in the span of one day with 0 replies, and each time getting more escalated, goes into that fact of a question of fact that the jury would need to decide if it would meet that threshold.
In Colorado, the Supreme Court said that they have to use the lowest punishment possible in all situations. Like they have to go as low as possible.
Some other factors that go into it are the medium or the manner of the communication, the fact that it was between two individuals over a messenger app and not in the public, the pattern, the frequency, the escalation, the fact that this all happened one day, very intense, and multiple messages with no reply. Whether the recipient reasonably thought and viewed it as a threat. Going into the countermeasure as well, the speaker had the recklessness, the mental state. That's again a question for the jury that they decide if they believe there was the mental state required to view this as a true threat. One moment, Ryan.
Wait, is he trying to get the messages suppressed? Is that what he's trying to do right now?
The defense's assertion that the statements were protected by speech is a defense that should be raised at trial, not a dismissal that should be made before any sort of fact finder should make those understanding mental ideas.
I think they're trying to get the messages suppressed. Okay, I guess that's his job, right?
Also, citing Counterman, that case was dismissed because there was no jury instructions for the mens rea for the recklessness in that case. However, the people are more than happy to add a mens rea jury instruction to go along with it to help the jury understand the true mental state of true threats. To go into fighting words, Your Honor, the defense have brought in the case of RC 411-1105 Colorado Appeals 2016. In that case, it is starkly different to this case in itself. In that case, Your Honor, this was a high school student talking to another high school student in the middle of the hallway saying one vulgar word. However, this is starkly different to this case, whereas the defendant sent multiple messages in a DM, meaning that it was between two parties and no one else was around. It contained explicit threats along with vulgar images to go along with it, not just a singular statement that the Court of Appeals saw that wasn't able to view as fighting words. And since it was privately sent to the victim, it creates a targeted intimidation tactic rather than some public exchange inside of school. Whether the defendant's statements fall within the categories of the factual question, the defendant cannot obtain a dismissal for merely labeling these statements as First Amendment privileges, and we would be objecting to any sort of dismissal of the counts. Thank you.
I was wrong. They're not trying to get the messages suppressed. They're trying to get the case dismissed.
Thank you. And Mr. Noblet.
And Your Honor, just to be clear, as to, just so I'm understanding correctly the argument of people, I don't think anything within counterman or any existing First Amendment litigation or case law indicates that anytime there's any true threats challenge, that it therefore has to go to a jury, that the court's precluded from making a determination of finding protected speech. I think that is one of the essential gatekeeping roles of the court when the issue is raised to determine whether something should proceed to a jury or whether it's more appropriately sequestered from and more precluded based on the constitutional challenge. So I just don't think that the law supports that claim that it essentially must go to a jury anytime there's a threat or there's an allegation of true threats pursuant to counterman. Beyond that, Your Honor, I think that there is something to be said for the fact that, private messages over phone, over Facebook I think that is.
Butter the judge up a little bit. Judge, you're way smarter than a jury. You know more about the law than any jury could, Judge. You could absolutely suppress these messages.
Analogous to RC in some ways that, the distance, the space in which messages are made is something for the court to consider, and how these things are either one, true threats, or in the context of RC, fighting words, because it does go towards distance of whether it can provoke or is likely to invoke a disorderly response. So I'll leave it at that.
Thank you. Court notes that I've had 2 cases that have been raised with different factual bases, and the court looks at these on a fact-by-fact basis. I found recently in one case, Mellis, essentially in that case, the only thing that happened in that case was he said, "Fuck you" to his wife. The court did not find that to be fighting words or true threats and dismissed that case for protected speech. However, the court looks at this on its facts as they stand in the Exhibit 1 and the affidavit. The court notes that essentially the 2 statutes are menacing, which is putting the fear of imminent serious bodily injury, and then also harassment with the intent to annoy, harass, alarm, repeatedly taunts, insults, challenges, or makes communications in offensive, coarse language or in a manner to provoke a violent or disorderly response. The court notes that under that statute, there can be essentially vulgar language, offensive language, and then also coarse language, and whether that falls under true threats and fighting words. The court has essentially messages alleged to have gone from Mr. Mitchell to the alleged victim, indicating that he's going to cut her pussy to her mouth, little dead cunt. He's going to pluck off eyebrows like I'm going to pluck off your titties. I'm going to rape and murder you. I'm going to make you a sex slave. So dumb you'll love it. And then continues to go on and on and on, repetitiously saying that he's going to end your fucking life, whore, and then continues to send her vulgar photos. I'm going to pull your brains out of your nose, you mummy. Those statements are more than what the court saw in regards to the Mellis case or the Pizzola case that the court looked at. The court looks at People v. Crawford. One moment. And the court notes that the court does believe that these statements are true threats. The original judge who reviewed this affidavit found probable cause for stalking. Counterman was a stalking case. Crawford was a stalking case. The people are going on two different charges here, but when the court looks at Crawford, the court notes that I do believe, based on the messages and the multiple messages and the language of the messages, these cannot be inadvertently threatening. These are directly threatening to the alleged hearer of the statements that there's multiple death threats, multiple threats of violence, multiple threats to end the individual's life, commit sex assault against them. These can also be inflammatory in the way that they rise above inflammatory words to fighting words. They're not just hyperbolic threats, insubstantial threats. He's also continuing to give photos over to substantiate his threats. There's numerous messages. It's just not one message yelled across the screen. They weren't inadvertent. It's not that he didn't know what his speech could have done. The court notes that based upon the multiple threats, the photos, the amount of messages, he was purposely trying to, or the court can infer, based on the totality of the circumstances, that he was reckless, at least recklessly trying to alarm, annoy, or retaliate against her by giving her true threats or fighting words. Additionally, that he was making true threats and planning and actually indicating he was going to have physical actions against her. And he was, I would think that anyone in his position would knowingly know that placing these statements to an individual with those photos would place or attempt to place her in this.
I know he was making a screenplay for Hollywood. It wasn't real.
It's also the attempt to place her in imminent serious bodily injury. One moment. I believe that there's enough here for mens rea on behalf of Mr. Wade that he consciously disregarded that these repetitive contacts would cause such alarm and distress, and these statements are true threats under what the court views in Crawford and Counterman. Wherefore, the court does not believe that essentially the statutes are unconstitutionally as applied to Mr. Wade. The court does not believe that the speech that has been alleged is protected speech under the case law provided. The court, based upon the totality of circumstances, and I look at the two essentially, one moment. The manner in which the statement is
I feel like it would have gone better for him if he would have wore a hoodie, his best hoodie.
communicated, which was over Facebook, the manner which whom it was communicated to a woman who he knew, and the manner of which the statement was communicated and the subjective reaction of the person. And essentially, this was extremely, extremely alarming to not only the alleged victim, but her family, herself. And the court would note that he's not just giving true threats to this alleged victim, he was threatening her entire family. So the court
Everybody give Nana a rose.
would deny the motion to dismiss on those grounds. The court denies the motion to dismiss in its entirety. And Mr. Nelwood, how would you like to proceed?
Your Honor, we're presently set for trial on May 18th.
Thank you. And in regards to that, I have a jury trial May 18th. Mr. Wade, let me talk to you. You are set to appear in person May 18th. Failure to appear for your jury trial will result in a warrant. The court will let you know that if you fail to appear at a jury trial, the court issues a cash-only warrant, and the court does not tend to change those warrants because the purpose of a bond is to bring you to trial. Mr. Ulrey, is there anything we need to do in regards to the jury trial set to commence May 18th?
I don't believe so at this time, Your Honor.
Is there any other preliminary matters, Mr. Noblett?
Your Honor, I think it's likely to rear its head, but there was allusion to Mr. Wade's purported Facebook profile and other messages. And I think that within discovery, there is indication of other messages that were from the other account to other individuals. There's been no notice of any kind of 404B that's been provided at this point. So I want to make sure that if we are proceeding to trial, that any trial will be focused on these messages and these messages alone, involving Ms. Bolter, just the ones that are openly sent to her.
If there is 404B, Mr. Ulrey, to other individuals, you'll have to put them on notice. We'll have to have a hearing on that.
What do you want?
Regarding other orders, the court will sequester all witnesses. Order of sequestration will go out. The court will order that law enforcement be excused from the jury pool. Is there any other issues that we need to address here today?
At this time, Honor.
No, Your Honor.
Given the pornographic nature of the exhibit,
Wait, Judge. I don't understand what she was talking about 404B. There's a co-defendant? So, I don't understand what she was talking about 404B. Someone help me. I missed something because I was giving green on roses. 404B is when there's a conflict. Like the same attorney is representing two different co-defendants. There's no co-defendant. I don't understand why she said that.
talk to my clerks as to whether we can have it essentially suppressed for just the parties to see, given the pornographic nature of it. Mr. Wade, do you understand the court's expectations of you?
Yes, Your Honor, but I do not have the ability to make it to Colorado on May 18th.
Well, then a warrant will issue
warrant
and you'll
will
be
bring
subject
you
to extradition. So
And
Mr.
what
Noblett,
is
be able to
extradition?
sell you a beer.
be aware of that. If he's telling me he's not coming to trial,
I
then
plan on being at trial through WebEx, Your Honor. Please, can you?
no, that will be denied. All trials are in person. I should have probably brought you back in person for this hearing. The reason why I have the trial ready.
How much money should I save, and how long do I need to be there for trial? Because I
$4
cannot
million.
go for, you know what I mean? I don't expect to have the funds, however much it is, and so if we could talk about that.
If you donate, your first donation of blood at those plasma places is extra money. You could get $400 this month if you try.
That'd be great, please.
I'm not giving you money.
You should give it 100% if you're going to go give blood.
I'm not asking for money. I'm asking for how long the trial will take, Your Honor.
Trial
Right.
scheduled for one day, Mr. Wade.
Okay. Yeah, I will be at court, Your Honor. I'm so sorry. There's confusion.
The reason why I usually do the pre-trial readiness conferences in person is a good faith showing on your part that you're trying to come up to trial, and you're telling me over WebEx, you're trying to tell me what to do with my courtroom.
No, ma'am, this is my 13th appearance, and I would never not appear to court. This is my 13th appearance.
In my courtroom in person.
I've never been to court 13 times in a row.
If you fail to appear, Mr. Wade, I'm going to
I
set
will be at court.
high cash bond.
I have done nothing to Emily. I love Emily. I'm so sorry. I've done nothing wrong. I'm so sorry.
So that's the order of the court. You have my expectations. I will see you May 18th. And if not, I will see you in jail eventually.
Thank you, Your Honor.
Thank you. The court will close the record in this matter and excuse Mr. Wade.
Zach, thank you so much for that. Now I'm going to have to start getting Colorado again. You know? Okay, it's fine. I have plenty of time. I have plenty of time. Zach, thank you so much for that. That was amazing. Okay, what was I doing? I had my lineup ready, and then Zach walked in. So we've been at it for an hour and 25 minutes. I got a 20-minute clip. That'll work. Riggins. Judge Riggins.
Is this guy Elmore? Okay, he speaks English. Okay. On.
Nothing I have comes close to what you just watched. So if you're looking for excellent court content, it's over.
Okay. All right. So I got Matthew David Cross. Is that correct? Alexis Eaton. Is that correct? You're Daquan. Is that right?
Daquan Elmore,
All right. And can you spell Daquan for me, please?
Biquan.
All right. Is there a apostrophe or anything in Daquan, or is it two words, or what is it? How's that?
After the I.
After the I, there's an apostrophe. Okay. Very good. All right. Each of you, good afternoon. I'm Judge Riggins. Today's your initial hearing. At your initial hearing, I'll talk how I run the court. I tell you how I run the court. We'll talk about your rights, and then we'll talk about your case. First of all, any time you come to court, be on time. Don't be late, because if you're late, a judge could find you in contempt. Being found in contempt means you could go back to jail, do community service, or pay a fine, so don't be late. Keep your addresses updated at all times. If you move, notify the court within 24 hours of change of address, email, or phone number. Back to court, I don't want to see your hero cell phone. Best thing to do is leave it in the vehicle or leave it at home. There's a good reason for that. Supreme Court says you can't record proceedings. I've had folks try and use their cell phones to do it before. I don't get trouble with Supreme Court. Each of you have the right to hire an attorney. If you cannot afford a lawyer, I can appoint one for you. All you have to do is ask. You can ask today or any day of the week that we're open. You don't need to wait for your next formal court date to come back and request a lawyer. But don't delay. There's important deadlines you could miss if you don't hire a lawyer within the proper period of time. Those deadlines can be as soon as 10 days from today on misdemeanor cases and 20 days from today on felony cases. In addition, you have the right to an early public trial here in the county where the offense occurred. You have a right to trial to the bench or to the jury. If you're charged with a misdemeanor, you get a bench trial.
Jen,
Trial
thank
to me
you
or
so
an
much.
odd number of
Thank
cases
you.
to the magistrate. If you're charged with a level 6 felony, you get a 6-person jury. Anything higher gets a 12-person jury. If you want a jury in a misdemeanor case, you can have it, but you must demand that jury in writing at least 10 days before your first bench trial setting. If you don't do that, you will lose the right to a jury trial in a misdemeanor case. At any trial, be it a bench or a jury, you are presumed innocent. You have the right to remain silent. You have the right to have the state prove your guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses against you and to subpoena witnesses to testify on your behalf. You have the right to appeal any conviction entered against you as well as any sentence imposed upon you. Today, I will enter a preliminary plea of not guilty that will become a formal plea of not guilty within the next 10 days on misdemeanor cases and 20 days on felony cases. And Matthew, your rights are a little different. Matthew, you're here on a petition to revoke your probation. You don't get all those rights. You get a few of them. You do have the right to hire an attorney, and if you could not afford one, I could appoint one for you. But you're here in the state of Indiana. It doesn't have to prove things beyond a reasonable doubt. They only have to prove it by a preponderance of the evidence. You do have the right to confront and cross-examine witnesses against you and to subpoena witnesses.
Zach, on an average day, how many women do the same thing Jen just did? How many thank you for their nightmares? No, I didn't. I told them it was rated PG-13.
This is to testify on your behalf. And you do have the right to appeal any decision I would make and be represented by an attorney on the appeal. If you could not afford an attorney for the appeal, I could appoint one for you. So back on Matthew, under cause number 73D02 2505 F6 132, I found you guilty of possession of methamphetamine on July 28th of 2025 and ordered that be served consecutively to 73D02 2504 CM 185. I put you've got apparently 543 days hanging over your head. I had revoked your probation previously once before and gave you 72 days. So let's see, 543 minus 72, 471 days. State of Indiana says I should revoke your probation for one or more of the following reasons. You did not report to a probation meeting. You consumed marijuana. You failed to report police contact within 24 hours on or about April 10th. You failed to notify of change of address within 24 hours on or about April 10th. That you falsely stated the make, model, and color of the vehicle you're driving when questioned by your probation officer on about April 10th. That you were charged and committed with a new offense of fraud, a level 6 felony under cause number 73D01 2604F6122. And that you committed a new offense of theft under cause number 73D01 2604F6123. You understand the nature of the allegations against you.
Yes, Your Honor.
Are you intending to hire an attorney to represent you in this matter?
No, I currently cannot afford one, Your Honor.
All right. I'll appoint public defender to represent you. In this case, I'll set bond the amount of $20,000, 10% cash allowed, cost you $2,000 to bond out. I'll set the matter for a fact-finding hearing May 28th at 10 o'clock. May 28th at 10 o'clock. Do you have any questions?
No, Your Honor.
20,000, 10% cash, cost him $2,000 to bond out. All right, Matthew, that'll conclude your hearing.
Thank you.
All right, Alexis, you're up next. 702-605 CM287.
Hello.
You are Alexis Elaine Eaton, is that correct?
Yes, sir.
What's your date of birth?
6/4/1990.
Do you read, write, and understand the English language?
I do.
What's the highest level of education you've obtained?
Ninth grade.
All right, it's my understanding, are you on
Children, my son needs me. I have to go. Tiffany's going to finish out this screen. If I'm going to sing Alice Cooper, Cold Ethel, no. So I'm going to go pick up my son. Tiffany's going to finish the stream, and it's possible that the stream doesn't end for like 30 more minutes. I'm going to end the stream when I get back. So when the clip's over, she'll probably say goodbye to you, or you guys will know it's over because the screen will go dark. Thank you for coming out today. I really, really, really appreciate it. I'll see you in about 6 hours, okay? So I'm going to press play, and then Tiffany's going to take over.
probation currently, is that correct?
I am, yes, sir.
Out of Marion County, is that correct?
No, Shelby County.
Okay. All right, let's see. Is it out of my court?
I believe so. My probation officer, his name is Michael.
Yeah, okay. Okay.
Yeah.
All right. Well, the state of Indiana says you did not only intentionally enter the real property of the Econo Lodge after having been denied entry by Econo Lodge or their agent committing criminal trespass, a Class A misdemeanor. Class A misdemeanors are punishable from 0 to a year in jail and 0 to a $5,000 fine. Do you understand that?
Yes, sir. I did meet with my probation officer earlier here.
Let me read the police report here. All right, I found there's probable cause. There's a 15-day probation hold, so
He did say it would be okay for me to go to a rehabilitation center. Would that be okay?
not today, it's not. No, you're going to sit in jail for the next 15, probably.
Going through withdrawals, because maybe not a lot, but at least partially.
Well, withdrawals suck anywhere you're at least there in the jail. You've got a nurse available. If it gets really bad, they can take you to the hospital. So I know it stinks, but the good thing is after 15 days, you'll be clean. So, and then hopefully you can hold on to that sobriety. It says Gateway Drive, but you're living at the Econo Lodge. Is that right?
No, I absolutely live at Gateway Drive.
All right. What's a good phone number for you?
317. I haven't activated my cell phone yet, so.
All right. Well, it's probably going to be moot. Okay. So you want me to appoint a public defender to represent you, I take it. Is that correct?
Yes, sir.
All right. Appoint a public defender to represent you. Set the matter for a pretrial conference June 10th, June 10 at 8:30 a.m. Your bench trial will be in the magistrate's court June 16th at 1:15. Your bond is $6,000, 10% cash allowed, cost you $605 to bond out. Do you have any questions?
No, thank you.
All right. Oh, Alexis. Hey, Alexis, hang on.
So is it Romans at all?
What's your full name?
Alexis Elaine Eaton.
Okay, there's no Romans or anything like that associated with it.
No, all that's my prior last names.
Okay.
Thanks.
Okay, thank you. All right, Daquan, you're up next. 3DO2 2605 CM 286. Raise your right hand. You affirm to paint the penalties of perjury. Testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Tell me your full name, please.
Daquan Elmore,
Date of birth.
12/17/2001.
What's a good address for you?
119.
I have apartment 36, but it's 3C.
3C as in K.
Okay. 3C as in K.
Oh, 3C as in K.
Cat.
Yeah.
All right, very good. What's a good phone? And that's in Lebanon?
Yes, Your Honor.
All right, Indiana, correct?
Yes, Your Honor.
All right. Phone number is what?
46. Yes.
Very good. All right, do you work?
Yes, Your Honor.
Where?
At Catalina Snacks.
How long you been there?
Since December.
What do you do for them?
I'm a forklift operator.
Okay. I see you're on probation out of Marion County, is that correct?
Yes, Your Honor.
What are you on probation for?
Possession of a handgun.
And it looks like you also have a pending case in Marion County, is that correct? Are you aware of that?
A pending case in Marion County.
Yeah, it looks like it.
No, I don't have a pending case. I have a hearing on violation of probation.
No, this is a brand new cause number. So let me look it up.
In Marion County?
Mm-hmm. My guess is you haven't had an initial hearing on it yet.
What is the charge?
I don't know. So I'm looking up. Yeah, I don't know. I think they've given me a bad cause number. 133328. Yeah.
When I his information, his last name, date of birth, that can come back to a Shakur.
Do you go by the name of Shakur Stevenson ever?
No.
Yeah, I know they must have given me the bad cause number. So
Yeah.
yeah, I don't think that's you. Yeah, because it was yesterday.
Yeah, that's not me.
Yeah, I don't know what happened. Okay. All right, so strike that. Not him. Well, being on probation is bad enough. So yeah, I suppose we don't need to pile on you. Let's read the police report here, see what it says. Said they locked you in at 113 and a 70.
I was going 90 miles per hour, Your Honor. But
You don't need to, I told you your rights. I'm just telling you what I'm reading.
Understood.
Yeah. Oh.
Cash bond deposit.
Oh, I see. Well, I found there's probable cause for the reckless driving. It's a Class C misdemeanor. Set bond, I'm going to put a 15-day probation hold on you and set bond the amount of $10,000, 10% cash allowed. Cost you $1,000 to bond out.
Sir, the 15-day hold, sir. I'm gonna miss a lot of days from my job.
Yeah, you will. That's why when you're on probation, you better behave and do well. And it appears to me at least probable cause to believe you did not. So you probably will. All right. Are you going to hire an attorney to represent you in this matter?
No, sir.
Okay.
Sir, how did it go up? It was just 600 yesterday, the bond, when they showed me on the paper.
Do you work?
You said, do I work?
Yeah.
Yeah,
What kind of work do you do?
forklift operator.
A forklift operator. That's right. You told me at the foods. How much do you make an hour?
1975.
Okay. So looks like you paid, I know why your name now appeared up in that other case because you posted the bond for that guy. You posted $500 bond. So
That's my brother.
that's your brother. All right. Well, looks to me like you might have enough. You got money to post for your brother's bond. You got money to hire your own lawyer, don't you?
That wasn't just my money, sir. That was my mom's money.
Okay.
Your
mom gave you the money to go post for your brother?
Yes, Your Honor.
All right. All right, I'll appoint a public defender to represent you then. I'll set the matter for a pretrial conference on June 10th, June 10 at 8:30 a.m.
Sir, is there any way that you can take away the 15?
Hang on a sec. Your bench trial will be June 11th. Is that right? No, that won't work, will it?
Yes.
No, but I'm saying, yeah, the next day. Yeah, the next day, June 11th. Yeah, June 11th. It's up to a 15-day hold. If the Marion County calls us and says, hey, we're going to serve him, or we want to serve, you want it released, I'll do that. But look, you were uncooperative with the officer. You did not answer his questions as required. You were uncooperative. You know, it's entirely, when your probation officer reads that, they're probably going to want to revoke your probation.
I answer every question he answered, sir. I mean, I answer every question.
That's not what I read. I wasn't there. I don't know. That's not what I read. It'll all be recorded, but you know, your probation officer may want to revoke your probation based upon everything they read. So that's what the point of the 15-day probation hold is to give them time to read that report and make a decision. So
Just saying so I can keep my job. I know if I miss 15 days, I'll be fired.
I get that.
I actually pay rent for my own apartment with my son.
I get that. That's why you probably shouldn't have been doing at least 90 on the interstate, you know? Speed limit 70. You're on probation. Your behavior is expected to be better than the average guy out there, you know? So I don't know what to tell you, but the law allows it, and that's what the law requires. So, all right.
Can you take away the 15 days, sir? Because I'm not.
Again, the law requires me to put a 15-day probation hold on there. We will contact Marion County Probation Department and see what they want to do with it, but it's entirely, I'm going to leave it up to them. No, I'm not going to not enforce the 15-day probation hold at this point. Okay. I'm just not going to do that. I do that with everybody. Okay.
$100,000 bond. Could you lower that? Because I don't have that type of money to be paying that.
I'm not going to lower it. No, you're on probation. And again, from what I read from the report, you have no contacts to our county. You were on cooperative with the police officer. And no, I think that's an appropriate bond. So, okay. All right. That will conclude your hearing for now. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf. Join in the laughter. Come and see for